Okay, we are live. It is Thursday, February 1st, and this is Senate Health and Welfare. Today we're taking some testimony, further testimony on S192 and then S197, and we'll have an update on the Blueprint expansion project pilot. So 192, I'm hoping we can get to some, to Katie and some new language that we'll have for the bill, and then we'll have to have a discussion, and maybe I'll work with Katie outside of committee to put together something, and Nicole or others, on the competency restoration piece, so we can look at language related to that report that we had yesterday. So we're getting to a stage where we can consider finalizing the bill. That's what I'm hoping we can get to a little bit today. So this morning we have Susan Nofi is here from Vermont Legal Aid Disability Project. Susan, you're up on the screen. There you are. Thank you for being here.
Good morning. Thank you for having me today.
All right, so why don't you introduce yourself and we'll listen to your testimony.
Good morning, Senator Lyons, Senators. My name is Susan Garcia Nofi, and I'm a staff attorney with Vermont Legal Aid's Disability Law Project. Thank you for having me here today to speak about S192 as it relates to placing people with intellectual disability in a forensic facility. The Disability Law Project works directly with people who've been civilly committed to Dale's custody under Act 248. Each year, the court is supposed to review the person's commitment and decide whether the person needs to stay on Act 248. Dale will do their own internal annual review with the individual and their treatment team, and then they file a petition for judicial review with the court with its recommendation. The court then appoints the Disability Law Project as the person's counsel to represent them in that year's annual review. And you, the legislature, fund us to take on those court appointments. I participated in the work group and presented on the annual review process. I can attach the slides from that presentation to my written testimony when I submit it. And I'm happy to answer more questions if you have them about that process, but my comments today are focused on S192 and our concerns. We are opposed to placing people with an intellectual disability who don't require a hospital level of care in an institution. The Act 248 commitment orders from the court typically require that the person live in a place chosen by the designated agency in Dale, and that they have 24/7 supervision and comply with treatment. And the court puts these substantial restrictions on the person's privacy and freedom and autonomy as needed to treat the individual and to protect the public. But that treatment and supervision is provided in a residential setting, such as a staff department or a group home, and not an institution. This gives people with intellectual disabilities the opportunities to build and practice their self-regulation skills in a community-based setting so they can eventually be discharged from Act 248 without risk to their own or the public's safety. Since Act 248's inception, Dale and the designated agencies have been successfully providing the supervision and treatment in community-based settings. There's been testimony that the forensic facility placement for people with an intellectual disability is needed because there are very rare instances when a person can't be served safely in a community-based setting. There's also been testimony about the substantial resources it will take to create institutional placements for this very small subset of a very small population. It's our position that these resources should instead be invested in the designated agencies so that they can ensure that everyone on Act 248 can be safely supervised and treated in a community-based setting instead of an institution. The designated agencies should have the resources to provide more intensive treatment when needed, more funding to hire experienced staff, train staff, and retain staff. And in cases where elopement is a concern, more security funding for more security features in the community-based placement where the individual is housed. And we do share the concern voiced by others about providing treatment to the population of people with an intellectual disability in the same lax setting as other individuals who do not have an intellectual disability and who've been adjudicated to be dangerous. We're gravely concerned that if people with intellectual disability are institutionalized in a forensic facility, they could get stuck there for an extended period of time rather than being transferred to their least restrictive environment. Page 6 of 192 defines a forensic facility as a placement for a person with an intellectual disability for an extended period of time. That language is in the bill itself. Dale's repeatedly stated in its testimony and throughout the working group discussions that there is a need for a short-term forensic facility placement to stabilize the person so that they can then be discharged to a less restrictive community-based placement. Dr. Frawley testified that discharge planning with the designated agency should really start from the day that the person is admitted to the facility. There's a disconnect between the identified need for a short-term step-down placement for people with intellectual disability and the bill's language defining forensic facility placement as being for an extended period of time. S-192 also denies people with intellectual disability the due process that is appropriately given to people with mental illness who are facing forensic facility placement under the bill. For people with mental illness, S-192 limits the initial order of placement in a forensic facility to 90 days. After that, if the state seeks to keep the person in the forensic facility, the commissioner has to apply for a new court order and request an extension and show that an extension is needed. That's on pages 12 and 13 of the bill. S-192 does not put any time limit on how long a person with an intellectual disability may be placed in a forensic facility. And then once a person with an intellectual disability is placed in the forensic facility, S-92 does not provide any right or any path to challenge whether their ongoing placement in that facility is needed or whether they should be discharged to a less restrictive setting for treatment. Under S-192, once the criminal court places a person with an intellectual disability in a forensic facility, no court is going to review that person's commitment until a year later when the Family Division does its annual review of Act 248 commitment. And even then, that court only reviews whether the person's it still needs to remain on Act 248. It doesn't review whether the person should be placed in a forensic facility as their Act 248 placement versus whether they should be in a community-based placement while they're on Act 248. If you look at pages 24 to 26 of 192, the sections on judicial review of Act 248 commitment, there's nothing in there that addresses forensic facility placement or discharge at all. There's nothing in the bill that would allow a person to challenge whether they still need to be institutionalized in a forensic facility, whether that is their least restrictive environment. And currently, the annual court reviews of Act 248 commitments are not happening for everyone every year. There are 29 people on Act 248. In 2023, the Disability Law Project was assigned as counsel in only 17 annual review cases. And in 2022, we were appointed to represent 14 people with intellectual disability in annual court reviews. Last year, we represented a client who had their first petition for an annual review of commitment, but that person had been committed to Act 248 in November of 2020. And so the first annual review is happening in August of 2023. No one on Act 248 should be going for more than a year between annual reviews, but obviously the stakes would be much higher for someone who is in a locked forensic facility. In addition to the lack of court oversight of forensic facility placement in the bill, the workforce shortage and the housing crisis increase the risk of people getting stuck in an institutional setting simply because there is no less restrictive placement available that they could be moved to. There's a critical shortage of staff to provide direct care to people with intellectual disabilities, and this facility would be competing with designated agency for direct care staff for people with intellectual disabilities. If the law is changed to authorize placement of people with intellectual disability in a forensic facility, which we oppose, the changes to the statute should not define forensic facility placement for people with intellectual disability as a placement that is for an extended period of time. It should require that less restrictive options be tried first before considering forensic facility placement. There should be a requirement that the court finds the placement in a forensic facility is in fact the least restrictive environment for the individual. The law should limit placement initially to 90 days, as it does in the initial commitment period for people with mental illness. And then if continued treatment of forensic facility is sought beyond 90 days, the burden should be on Dale to seek an extension, just as the burden is on the Commissioner of Mental Health to seek an extension under 18 VSA 7620. And that person should be provided with court-appointed counsel at the proceedings on their extended placement. Any extensions beyond the initial 90 days should also be limited to 90-day increments for people with intellectual disability, given that the gap in the system of care for developmental disabilities that's being asserted here is the need for a short-term step-down placement, and also in light of the historical context of institutionalization of people with intellectual disability. Finally, if the legislature creates a forensic facility placement for people with intellectual disability, there must be protection and advocacy system access and resources allocated to provide protection and advocacy, as well as counsel for the court proceedings on extension, commitment and extension on to a forensic facility. As stated in the executive summary of the working group report, the group voted unanimously in support of robust protection and advocacy system level access to services in the forensic facility. That's on right in the at the beginning of the report. Funds would be needed not just for the additional hearing and representation regarding the continued placement of an individual with intellectual disability in the facility, but also to cover the added cost of the independent monitoring and investigation activities under protection and advocacy. And those are the outline of our objections, and which are more also captured in the report. Happy to answer any questions.
Right. So obviously, this bill was written before the final report came out, and I think folks do understand that. And one of the things that I had thought about was to equate any decisions about folks with intellectual disabilities to make it comparable in the language, the same as the treatment for due process and other treatment for folks with mental health. And it sounds like you have moved in that direction a little bit. Your biggest concern I'm hearing is having not an extended stay, that there be 90 days, that there be a check-in, and some way of providing support services should there be that one person who becomes placed in a secure facility. Secure. That's right, Senator. Yeah, okay.
That's right, Senator Lyons. To be clear, we oppose the forensic facility placement for intellectual disability individuals at all. But if it were to go forward, then yes, we would at a minimum want the same protections as the mental health side, but with 90-day increments for the reasons stated.
We understand that, and just to also clarify, because the whole committee wasn't on the working group, that this became a tension within the working group around differences of opinion for folks with intellectual disabilities who had committed some very serious crime as compared with those with a mental health disorder who had committed a very serious crime. We're talking about, as we learned the other day, one person out of maybe a total of 29 folks with intellectual disabilities who are being placed through the judiciary. So that we need to be clear on that. We're not, we also understand, at least I understand, the need for more consistent support services within for residential facilities and for designated agencies. And I also understand the difficulty of identifying a workforce to care for someone. If we had that one person in a residential facility, we heard the other day an estimate of at least 3 people 24/7, which makes it, a lot. But I do not in any way disagree with your assessment of the need for greater attention to services and support and step down and residential facilities for folks with intellectual disabilities. There's no question about it, and we heard from folks yesterday, as a matter of fact, on that topic. we're not talking about everyone here. We're talking about one person who's committed a severe crime. Senator Williams has a question.
Just, do we have the testimony? I don't see it.
No, she's going to submit it.
Okay, and who do you represent again?
I work for Vermont Legal Aid's Disability Law Project.
Thank you.
Okay, and we'll take another question, and we're going to go to Jennifer Pullman, just so she knows. Go ahead.
Well, first of all, a question for you. When we have just one person testifying, can we make this full screen so that we're not seeing all the other blank boxes? And have just see the, yes, exactly. Thank you. That's better. Yeah. It's hard to look at just one little block. Thank you, Kiki. Susan, thank you for your testimony. I really appreciate it. And I share your concerns about sort of mixing these populations in a forensic facility. I think it's where what we seem to be doing, or what the whole proposal seems to be doing, is saying we have this physical facility that we need to find a use for. So let's put these two populations there because we need to use this space, rather than thinking about we have these two populations that need services and rehabilitation and help, and how do we best meet both their needs. So we're trying to put a square peg in a round hole, or whatever that saying is, it seems to me. So I'm curious, you mentioned the providing more support and resources to our designated agencies to be able to manage this population in these situations. Can you describe a little bit more about what you think that would look like, or what it does look like if that's currently happening?
Sure. I think staffing obviously is a big challenge. So it takes resources to retain experienced staff. I would also direct your attention to the working group report. We had a presentation from a provider who sort of talked about the idea of placing people in a forensic facility, and one of the challenges that she mentioned about the community-based settings is that they often use entry-level staff positions, and it says in the report the staff have minimal experience, get only basic training. So, and don't misunderstand me. We have seen clients served very well in these settings, and the designated agencies do a good job and keeping in treating these individuals. But certainly if the need that's being identified here is more intensive treatment but more staffing to supervise, then we would argue that the resources should be given to the designated agencies to provide that more intensive staffing and treatment in a community-based setting. And we recognize there, for a small number of individuals, there's been testimony about risk of elopement and so forth. And some of our clients our Act 248 clients are in settings with, for example, door alarms or a locked fence. That wouldn't be appropriate for everyone, but for a small number of individuals, that is their least restrictive environment. But they're still in a residential setting where they get to, practice their regulation skills and have, and they're in a residence. They're not in a hospital. They're not in a hospital-like setting. And keep in mind, some folks, although the goal is eventually for the person to be treated and get to a point where they can come off of Act 248, some people stay on it for a very long time because they just don't get there. And so that being in that in a community-based setting, in a more residential setting, even if it's a fairly secure residential setting with a lot of support and supervision, it's their life. They have some dignity and quality of life, and it's not being in a hospital-based setting. And again, I know this is being proposed only as a short-term thing, but our worry is that for lack of other alternatives, someone could get stuck in there for quite a while.
Yeah, that hasn't been the intent of the working group's report, that one individual. So we're not talking here generally about what's missing and what's lacking in the community for all the folks with at 248, but we are talking for that one individual who has committed a really, horrible crime. So that's
But-
where we are.
It's one individual now, it doesn't, there could be
No, it could
multiple
be more.
individuals in
Depends on how-
we're not, this is not proposal to just deal with what the situation is now, it's a more long-term proposal,
It
so
is.
there could be multiple people in the future.
Whenever there's a
Yeah,
horrible crime committed by an individual with, an intellectual disability. One more
Just for
question.
you,
Uh-oh.
we talk about intellectual disability, but is that synonymous with developmentally disability?
I will ask Susan
Okay.
Nolfi to respond.
Yep.
Yes, that's a good question. Generally, it is not. There are different types of developmental disability, but
Right.
in this context, we're only talking about intellectual disability because that's what Act 248 covers. And I know
Okay.
right, and there's been mention of competency, and I I don't know if we'll have another opportunity to address that. That's probably a little outside the scope of this bill, but I think it's worth mentioning that for someone with an intellectual disability, that's defined as significantly sub-average cognitive functioning that's existed since childhood. They never developed the cognitive capacity. So when we hear about
70 IQ, isn't it?
correct, and it had to have
Yeah,
been
those are
that
the
way
rules everyone should-
right since before they were 18. So when there's mention of competency restoration for someone with that kind of lifelong lack of cognitive ability, it
Let's
question,
not
how
get
can
to
you restore
competency.
something that wasn't there?
I would ask that we not go to competency.
Certainly.
We will have you back in, should we have any, we'll have the language, theoretically, we'll have language on this bill related to competency restoration, and then at that point, we would welcome your testimony, but I think we need to stick right here with, this particular topic. Good, and I appreciate your answer very
Yes,
much,
thank
very
you.
helpful. Okay, all right, so let's, Susan, don't go away because obviously your expertise is significant, and thank you for your help. So
Thank you.
you can, if you shut your screen now, then we'll talk with Jennifer.
Very good. Thank you.
Thank you. Thank you for being here, Jennifer.
Thank you,
So why
and
don't
good
you
morning.
introduce yourself for the record, and then we'll listen to your testimony.
Not sure if I froze, which is very awkward if I did, but good morning, senators. My name is Jennifer Pullman. For the record, I am the Executive Director of the Vermont Center for Crime Victim Services, and I'm here today with Kelly Carroll and Joy Fortendick to talk about the impact on victims and survivors in these cases, especially differentiation between the criminal justice process and when the case goes through the mental health process. And what I'm going to speak very generally, because I know we have very little time. I also was the vice chair of the Act 27 working group, and do what we submitted for the committee page that you can access. We're not going to go over those in the interest of time. And I do want to also indicate that we got the latest version of S192 just this morning, and that for me in the center, we're really encouraged by the direction that the committee is going in, or at least that's its bill suggests the committee might be going in, because we have always been very concerned about the significant dichotomy in terms of what rights victims have in a criminal justice process versus, again, when it goes the other route, as we call it. And victims of the same crime, the same violent crime, if they go through the criminal justice process, they have a multitude of rights at every single point along the continuum. And when it goes the mental health route, or when it goes to that other process, it's been like a black hole where victims and survivors of very serious crimes get no information whatsoever. And the foundation of victims' rights is really based on three principles: the right to information, notification, and to be heard. And those are, again, the pillars upon which all of the different statutory rights that we have for victims currently in the criminal justice process are built. And those are the three pillars that are essential for victims to be able to move forward, to be able to get information that is basic to their own safety planning, basic to protecting their own family, and to understanding what is happening in terms of any accountability. So again, really want to highlight that contrast. with respect to what is currently existing. And our position is that stark dichotomy does not need to exist. And in fact, the work of the Act 27 working group and some of the language that's been before you, and for example, I understand the committee was working on version 2.3 and working off of that, shows language that, again, in Act 27 was agreed to, that there are certain pieces around discharge, around hearings, that there can be a role that a victim survivor can play and actually should play. And I'm not going to get into weeds on that because I want to save time for Kelly Carroll and Joanne Kortendick to be able to speak from not just the perspective of victim survivors who have been seriously impacted, but how they've transformed that into advocacy that they have been involved in this building and outside for for several years. So I want to give space for them to share their experience. So if it pleases the chair, if I may yield my time to Kelly Carroll now.
Okay,
Thank you.
that's fine. Welcome, Kelly.
Good morning. Thank you. I'm a little nervous. This was easier before I started listening to Jennifer. So I'm sorry. My name is Kelly Carroll. I've been a Bennington resident since 1969. And 3 years ago, my daughter Emily Hammond was murdered in broad daylight in downtown Bennington on a Monday morning. It was Martin Luther King Day. One case should not define law, but one case can identify gaps in the system, and that is exactly what Emily's murder does. In 2016, her killer was arrested twice for and released with mental health restrictions and stricter mental health restrictions. In 2018, he was arrested during a violent home invasion and attempted murder for trying to slit the throats of the family that lived there. In 2018, he was found competent to stand trial. The Defender General's office had a second competency evaluation completed, and he was found not competent to stand trial. He went to family court, and then he went to the hospital. After about 18 months, he was released into the community at home, secretly, no warning to the public. This began a months-long terror spree with multiple residents in Pownell, Vermont. In November of 2020, he made a video claiming to be a murderer with not competent paperwork from the state. And with that paperwork, he could kill anyone he wanted, and the state of Vermont couldn't do anything. That was a 15-minute video of him laughing at the state and at the institutions that support all of our legislative laws and processes. 7 weeks after he made that video, he hunted down my daughter and he slit Emily's throat. We go to court every 60 to 90, and now about every 120 days. Keep in mind, competency is not a medical diagnosis. It's a court opinion after an adversarial hearing, and competency can be fluid and it can change. I started advocating with S3, which is now Act 57. That law gave the state the opportunity to request their own competency evaluation. In 2021, after he murdered my daughter, he had his third competency evaluation. That was, he refused to complete it, and he was found not competent to stand trial. Thankfully, S3 Act 57 gave the state the ability to go in and ask for another evaluation, which they did. That one took about a day and a half, and it came back that his competency was fluid. He had some issues, but maybe after, so many hours, he could pay attention. And then after so many hours, like most of us, his attention span starts to wane. So they at least had the opportunity to go in and have that done. And when they did that, everybody just decided that they were going to have a deal. And what happened was everybody agreed that he was not competent to stand trial. So instead of going to a contested competency hearing and a hospitalization hearing, the decision was made that he would go to the Vermont Psych Hospital. And should the psych hospital determine that he could be released, then he would either go to, and I forget the name of it because it's closed now, Mid Valley. It was replaced with the Essex facility, but he would go there, or he would go back to jail. And one great thing about S3 was it did allow the state's attorneys to notify victims about custody changes. So we go back to court, we go through the deal, and we get notified right before Christmas in 2022 that he is going to be going from jail to the hospital. And then we get notified right before Easter in 2023 that he is going back to jail. We honestly had no idea what happened. We thought he hurt somebody else, but it turned out that the hospital felt that well, first of all, he did not meet acute level care. So there was no reason that they could keep him there because it was out of CMS compliance. And then they found out they couldn't send him to the step down place because there is no there's a gap in service. There is no ability for involuntary medication. There is no ability for them to restrain him should he become violent again and attack either another patient or somebody working there. So they went and now he is back in jail awaiting. He just had competency evaluation number 5 competency evaluation number 5, and that one was done in an hour and a half, and the evaluator decided that he was not competent. And one thing, if you all recall, during all the testimony with S3, the Defender General did say that they were going to clog down the system by requesting evaluations for everyone, which they did. And I believe Karen Barber testified last year with S89 requesting psychiatrists and psychologists to both do evaluations, and that backlog has decreased. So the work that's happening with S3 and then again last year with S89 is making an impact. And I thank you for that. S3 had a working group. I was fortunate enough to participate in that. That working group could not come to a consensus on forensic facility or competency restoration. S89 created Act 27. I believe you have that report. And there was a consensus that individuals with intellectual disabilities, as well as mental health, should be or could be considered for the forensic facility. It was not unanimous. I realize that there are people that have different levels of need between mental health and intellectual disabilities. However, dangerousness is dangerousness. And that's something that I think that we need to remember. And it would be really great to have everybody in the least restrictive setting. This is my daughter. She is not in the least restrictive setting. And victims need to matter. And victims should be heard. I am Emily's voice in every place but the court process. I was fortunate enough, because I keep writing, but I was fortunate enough to testify last year before Senate Judiciary. And I told them that the only time Emily has been mentioned in court was when I was told I had to put her picture away. After I testified to that, we did have a new judge, and she has mentioned a couple of times that Miss Hammond's family has been present. And I can't tell you how huge that is. It's been reported that Vermont has over 80 open murder or attempted murder cases in our court system. And with that violence, we've had more over the last couple of months. So we're probably pushing 85 to 90 cases. Now, I can't tell you how many of these cases are mental health or ID related. I'm sure you could get that information, but it's not accessible to me. But what I can tell you is if you are a victim in a criminal court case, you have a voice, you have rights. If you are a victim in a mental health case, you have no voice, you have no right to notification, you have no opportunity to be heard. The family of the mom that was stabbed over 100 times in Wardsboro has no voice. The family of the social worker murdered in Brattleboro has no voice. Emily has no voice. We had a local case with 40, where a victim or with an offender with 47 charges. He went through the whole not competent, and he was recently found competent to stand trial. He has 47 charges. He has 35 victims. And those 35 victims now have a voice. But the truth is that they should have had a voice all along. And I know that there's been some changes in the bill this morning that have put some of the victims' notification and everything right back in there. And I thank you for that. I encourage you to support that. And just to let you know, we go back to court next week. So when we do that, the trauma Band-Aid has to come off. Joanne's going to talk. She's been suffering a lot longer than we have. But I think that you really need to think about what's going to happen, because if he's found not competent, what are you going to do with him? Where's he going to go? We don't have any programs in place. We don't have any systems. And the last thing I want to leave you with is I've listened to all the testimony this session, and Karen Barber had testified, and I'm trying to find my notes because I went off script and I apologize. But the S89 or Act 27 from last year established a Vermont forensic facility, and it was supposed to be in place for July 1 of 2024. And you've heard from Karen's testimony that the timeline needs to be adjusted, or in other words, delayed, partly because of the ID question and the related policy prep, but also no quote for the cost estimation came in. And as a taxpayer, I find this delay frustrating. As a grieving mother, I find it beyond angering. It's difficult to get Vermont news in Bennington. You know, we get more New York. But all I keep hearing is that public safety is a priority for the Scott administration. I hear public safety is a priority for the legislature. I hear that people say that there's a perception that Vermont is not safe. And I can understand the paperwork delay, because some of that does have to rely on whether or not there's somebody with intellectual disability going to be served. But there was testimony about just getting a cost delay because it wasn't a priority for buildings and grounds to get a quote. And I just don't think that they should be setting policy. I think if the legislature last year said we should have this in place and the governor signed that we should have it in place, I don't think a department head should be doing policy. I thank you very much for listening to me. I hope you support competency restoration when it comes up next session. I hope that you put competency restoration within the forensic facility. And again, thank you for letting me be Emily's voice. And I just want you to know that the worst thing that you can do is think that it won't happen to me. So please remember the victims. And thank you again.
Thank you so much, Kelly. We appreciate the comments that you've made, and the passion and the emotion and the real difficulty that you brought to the testimony. So thank you. Is she still up there?
Thank you.
Or no?
Yeah, I try to cry in
but,
private. I'm sorry.
I would like to just share with you from my perspective that your experience and the loss of your daughter has been one of the guiding thoughts that I've taken into the work that we've done, and that we'll continue to do that. So Emily's voice is being heard, and that's important.
Thank you. I hope that we get to hear it in court or speak in court. And Senator Lyons, I really want to thank you, and Senator Sears, for all of your support. And I thank the rest of you. I don't write to you as often. And from a victim's perspective, Jennifer Coleman is absolutely priceless. And I hope that you listen to her, because again, it's a very, very small portion of the population. And for all of those people that say that we need to go into the least restrictive, I am 150% behind putting the meat and potatoes into the community program so that we can intervene before people like my daughter's killer become the killer that he was, because he started with intervention with the mental health system in 2016. And had we as a state done better in 2016 for him and others like him, we wouldn't be having conversations like this today. So it really, totally off topic, look at the whole system, mental health system, forensic health system, and let them collaborate, because we'll all be better for it. And thank you again for letting me be her voice and for all you do for Vermont. I appreciate it. And I'm sorry I ran over time.
No, you're fine. And there is a question, I don't know whether it's for Jennifer Pullman or for you, but Senator Hardy has a question.
Thank you, Madam Chair. Excuse me. Thank you, Ms. Carroll, for sharing your daughter's story. I am so sorry
Thank you.
for all that you've been through. It's horrific. I can't even imagine. I do have a question about the sort of timeline you were talking about, because I'm trying to understand what I'm hearing from you and others is that there's not notification of victims, but then in your story, you said you had heard about him being placed in different types of facilities. So was it just hearsay, or did you get any kind of official notification about him moving in and out of prison or in and out of different facilities? Do you know what I mean?
We got specific notification because it was written into the case, and it was also in S3 Act 57, but there was notification with the forensic facility, and Joanne will speak next, is a whole lot better with the legal aspect of it and the terminology. But some of that was taken out, and there was some terminology in S89's 2.3 draft that didn't make it into 192. So we're more mental health, I think, but it should also be in the intellectual disabilities with that, and it should be part of the norm. If it's not requested, it's not requested. And again, you're only talking small percentage, high level violent crimes, but we got it. It was part of the deal. I'm not sure we're going to get it the next time because he's going to go into family court. And so I'm not sure.
Okay, I understand. So it was specific to your case. It's not a general.
It was, Joanne, I'm going to ask you to help me out. It's in S3.
Right. Here's what I'm going to suggest.
Just one more comment, if you would. I'm super impressed with how much you're following all this legislation and how much you know. As an outsider, you know an incredible amount. It's amazing. And thank you for looking at the big picture too. And we'll get this sorted out with other people. But thank you, Ms. Carroll.
Well, thank you. And thank you for listening and reading my letters.
Yeah, so the bill, when we look at the bill, we're going to have those questions, or good questions to ask, and how can we improve notice. And some of that will be a judiciary issue from the court responsibility versus this. But
it's just confusing because there's a new draft that has different language in it.
That's what we're going
through.
to.
We haven't walked through it yet.
No, that's next on our agenda.
Got it.
So, and there will be some changes. There may be some changes further that we'd like to have in the new draft. So Katie, and what I'm going to suggest to the committee is this, and Stuart Schuer is here, and Rebecca, you're here. And so we can go back with questions to the folks who are with us on the screen for clarification, and as well as with folks who are in the room. But Katie, let's go through the new draft, and then, as I said before, we may have further changes to the bill based on what we're hearing. And then we may have some, in addition, related to competency restoration. It's going to be the whole thing. It's going to be something we don't know. So Katie, you worked with Stuart Schuer on this, the chair of the working group to improve the bill. And let's look and see what it is. Yes, I read it last night, and I do have some other suggestions as we go through what we'll see.
Okay, Katie McLean, Office of Legislative Counsel. So before we look at this draft 3.1 of the bill, I should pause and tell you what it is and what it isn't. So there is language that's highlighted in yellow that represents the changes that were made since the bill was introduced. What I tried to do with this draft is I tried to clarify the existing commitment process without making huge substantive changes, and then kind of layer on top of that the forensic facility concept. Also, when we last met, we walked through a House Judiciary draft from last year. So I tried to pull out the provisions that were not in the Senate version and put those into this draft. I've labeled them as House Judiciary, so you know where the drafts were and were not alike. And I tried to layer all those pieces together. Yeah.
That's H89. That was, yeah.
So this isn't to say that you might make different policy choices as you move on, but this was just an effort to kind of bring all the pieces together, make it clearer, make it chronological, trying not to make those huge substantive changes to commitment as I went, just a clarifying piece. So that is what the draft is. I thought it would also help to talk through what the existing commitment process is, because I think that would maybe help you understand. And we've spent so much time talking about the commitment process for individuals with mental health conditions, and it's different in the intellectual disability system. So I think it's maybe helpful to understand that. So whereas in the mental health system, there is an initial petition that's filed by the commissioner, most often the commissioner, for involuntary treatment. That is different in the intellectual disability context. So in that context, a person who's subject to possibly an Act 248 commitment, there would be a competency evaluation. The court would make a decision whether or not the person is or is not competent to stand trial. If there's a finding that the person is not competent to stand trial, automatically, without a petition, the court starts, the criminal division starts looking at whether commitment is appropriate, whether the person meets the definition of a person in need of custody, care, and rehabilitation. It's helpful for me, maybe this visual is helpful for you, to sort of think about this as a Venn diagram. So in one circle, you have competency, and competency is whether the person is competent to participate in their defense. They understand the charges against them. They can help their attorney. And the other circle is a person who meets the clinical criteria of a person in need of custody, care, and rehabilitation. Sometimes those circles overlap. And then that middle population in the intellectual disability context are the people who are committed to the custody of the commissioner of Dale. So maybe that doesn't mean anything to you, but to me it gave me sort of a helpful image of the population that we're talking about.
Somewhere there's another circle that's incompetent to stand trial, correct? Or are those the same as the second bubble?
So if somebody is not competent to stand trial, I mean, they're in one of those circles.
They are, okay.
Yeah.
I think I need the actual Venn diagram.
Okay.
Yeah.
Yeah.
Good. That's a good diagram. You explained it
I
to
got
me
my
the
own
other
mental
day.
picture of it.
Yeah, me too.
I'll try to put something together for you.
No, it's good.
Yeah.
You explained it to me the other
Yeah.
day, and I said, oh, okay. This,
Yeah.
makes everything clear.
So another distinction between mental health and intellectual disability, as you know, with mental health, there's an initial order for 90 days for commitment. And then there's the continued order, and that is for up to a year. In the intellectual disability system, that kind of dichotomy doesn't exist. There's an order that is for an unlimited period. However, there is an automatic annual review, and there's language that the person themselves can seek an earlier review 90 days after their initial commitment. So those sort of systems are different. And that is what I was trying to clarify as I went
Can you
through.
say that again? The individual can request?
Yeah, so working with their attorney, they can seek a review earlier than the annual year review. So after 90 days of commitment, they could seek a review.
And that would be the case in the forensic facility as well. Or we're still figuring that out.
I think that's a policy question. So yes, I think it's an open question, how you want to do that. So that's another sort of thing that you have to keep distinct in your mind as we start walking through this language. So there's the issue of commitment, the issue of actually being in the custody and care of the commissioner. And then there's a separate issue of, okay, this person is meeting that standard, person in need of custody care and habilitation, where do we place them? And that's where the forensic facility comes into play. So they're sort of two different determinations that the court has to make. First, should the person be in custody? And if so, what is the appropriate placement in a least restrictive setting? Okay, so now
let's do this. Let's go through the bill. We'll look at the decision-making points.
Yep.
And then the next time we'll come back to it, maybe we'll be ready to have a broader discussion, because we are a little bit cramped today. I'm going to go until about 11:15. I know it's not much time to do what you need to do, but we'll try and do that.
Can we get paper copies of the bill?
Well, you can ask for that. You might want that this time because of the decision points. So Kiki can, who would like, let's do this. Who would like a written copy of the bill, printed copy?
I would.
Just Uno.
Just
So,
me.
but it should be in color.
Yeah, and double-sided. Last time I made the mistake of printing single-sided. Yeah, that's
Yes. Okay, go ahead.
like
Okay.
another tree.
Okay, so I'm just gonna walk you through the highlighted language because I know we're crunched for time. So one thing I did is try to just make sure we're using the same definition of forensic facility throughout. The definition, according to this draft, would live in the sort of mental health section of Title 18. So now we're cross-referencing to the same language in Title 3. We're cross-referencing again to the same definition. And this is all the language on the mental health system that I'm scrolling through. So I'm not going to stop here. I didn't make any changes here. Okay. So that will bring us to, is this section 12? Section 12. So the major changes are in section 12 and 13. So section 12 is in Title 13, our criminal justice title.
Page 19, is that where you are?
Page 19, yeah. So we don't have a lot of changes from this draft to the next, except specifying that there's this concept of continued commitment for individuals with intellectual disability, which is not a new concept to the previous draft, but it's added to clarify. So I think I might just go through all of this language to sort of, so we're all on the same page. So in subsection A, if a court finds that a person is in need of custody care and habilitation, the court is to issue an order of commitment to the Commissioner of Dale for placement in a designated program in the least restrictive environment consistent with the person's need for custody care and habilitation for an indefinite or limited period. In subsection B, the commitment procedures for an order initially issued pursuant to A that we just looked at and for discharge from an order of commitment or continued commitment occur in accordance with Title 18. So much the same way it is now, Title 13, which is looking at the initial order of commitment, sort of kicks all of the process piece to Title 18. And that is the way it is now, but there are changes to my cross-references because I've created new sections to keep us organized. And subsection C, in accordance with the process set up in Title 18, if the commissioner seeks to have a person committed pursuant to this section placed in a forensic facility, so first we have commitment, then we have placement, the commissioner shall provide a statement setting forth the reasons for the commissioner's determination that clinically appropriate treatment and programming can be provided safely only in a forensic facility, including the recommendation of the panel. So that was the Human Services Community Safety Panel that we spent a lot of time talking about last time I was here. So that is in Title 13. And then we get to Title 18, and this is where all the process lives for these commitment proceedings, continuing to hold a person after review, and eventually discharging a person. Unlike the previous draft, I've put all of these sections into one section. I didn't explain that well. So before I amended each section individually within this subchapter, now I'm just amending the whole subchapter, which is why Title 13 now amends the whole subchapter 3 instead of going section by section. So first we have our definition section. Not a whole lot of changes here, except I've added the definition of forensic facility to cross-reference the same definition used throughout. This is where our definition of person in need of custody, care, and habilitation lives. This is sort of the clinical standard for somebody being committed. And then we have our definition of person in need of continued custody, care, and habilitation. And then the definition of victim. This addition of the definition of victim is because I've pulled in language from the House Judiciary draft that was not in S-192 that references a definition, that references victim. So now we have the definition here. So like previous drafts, sections 88, 40, 41, and 42 and 43 are all struck through. That is not a change. This was the conversation with Dale that it didn't have a practical effect because sub-chapters 1 and 2 had previously been repealed. 8844 has not been changed since you've last looked at the draft. This just adds, the change there is to add in the concept of continued custody. And then 8845 has been rewritten. So what had been one section, this judicial review section, has now been broken into 3 sections. 8845 deals with the initial order for custody, care, and habilitation. That is the initial order that after somebody has been determined not competent to stand trial, the criminal division of the Superior Court is looking at whether the person meets the standard of commitment. In 8846, we look at the annual review of somebody held in this type of custody, and also a petition to continue to hold a person in this type of custody. And then in the 3rd section that I've added, 8847, we're looking at discharge of a person. Discharge of a person either by a court or administratively by the commissioner themselves. So in section A, if a person is found incompetent to stand trial, the criminal division of the Superior Court is to automatically schedule a hearing and determine whether the person is a person in need of custody, care, and habilitation and requiring commitment.
Excuse me. Pause for 1 second. Sorry.
Yeah.
Got it. Thank you.
In subdivision A2, the commissioner's recommendation that a person be placed in a forensic facility, if applicable, because not in every case will the commissioner seek placement in a forensic facility, that is to be filed with the court in advance of the commitment hearing and shall include the following. So that the court is sort of looking at those 2 pieces together, commitment and placement. So what will the commissioner submit? The commissioner would submit the reasons for the commissioners determine that clinically appropriate treatment and programming can be provided safely only in a forensic facility. And it would include the recommendation of the Human Services Community Safety Panel. In subsection B, the commissioner or designee shall attend a commitment hearing for custody, care, and habilitation and be available to testify. Similar language was in your previous draft. All persons to whom notice is given may attend the commitment hearing and testify, except that the court may exclude those persons not necessary for the conduct of the hearing. In C, we have language of the Vermont Rule of Evidence and procedure applicable in all civil cases is to apply to all judicial proceedings brought under this subchapter. And in D, this is the order itself. If the court finds by clear and convincing evidence that the person is a person in need of custody, care, and habilitation, so they meet that standard, the court is to order the person committed to the custody of the commissioner and receive appropriate treatment and programming in a designated program that provides the least restrictive environment consistent with the person's need for custody, care, and habilitation for an indefinite or limited period of time. And then in E, so that was the commitment piece. In E, we're looking at the placement. If the commissioner has recommended to the court that the person be placed in a forensic facility, the court, after determining that the person is a person in need of custody, care, and habilitation, shall determine whether placement at the forensic facility is both appropriate and the least restrictive setting adequate to meet the person's needs. If so determined, the court shall order the person to be placed in a forensic facility for a term not to exceed the duration of the initial commitment order.
There's nothing in the initial commitment order that limits the time.
No, it says, right now it says, what does it say? Indefinite or limited period.
Okay.
Right. And so this says that the placement at the forensic facility could be whatever length that the commitment is. Again,
Right.
doesn't mean it can't be changed, but that is the language right now. 8846. Okay, so far we've been talking about the initial order. The person is not competent to stand trial. The court makes a commitment. So now we're moving on to the person has already been under an order of commitment, and should they continue to stay under an order of commitment? In A1, at least annually, the commissioner is to initiate a judicial review in the family division of the Superior Court. Notice that switch. So previously, it was the criminal division making that order of initial commitment. But now it's the family division who is looking at whether the person should continue to be in the commissioner's custody. As to whether a person initially committed is a person in need of continued custody, care, and habilitation. That is the defined standard that you set out in the definition section. The commissioner shall, by filing a written petition, commence proceedings for the continued custody, care, and habilitation of a person. The petition shall include the name and address of the person alleged to need continued custody, care, and habilitation, and a statement of the current and relevant facts upon which the person's alleged need for continued custody, care, and habilitation is predicated. Notwithstanding the previous subdivision, a person may initiate a judicial review under this subchapter anytime after 90 days following an initial commitment order. So just because the automatic review is every year, this allows a person with the help of their attorney to bring a review after 90 days. In subdivision 3, so far we've just been talking about the commitment piece. Is the person in the custody of the commitment of the commissioner? And 3, we're turning to the placement. If the commissioner seeks placement of the person alleged to need continued custody, care, and habilitation at a forensic facility, the petition for continued custody, care, and habilitation again expressly states the reasons for the commissioner's determination that clinically appropriate treatment and programming can be provided safely only in a forensic facility, and include a recommendation of the Human Services Safety Panel. You'll see I have recent in parentheses because last time we spent a lot of time talking about would the panel be doing another review or are we basing it off the initial review? So policy discussion.
For us, right.
Yep.
We'll have to go through and look at it. Yeah.
In subsection B, upon receipt of the petition, the court is to set a date for the hearing. Again, I have a time frame question if the committee wants to create a time frame, which is to be held in accordance with the subsections B and C of the previous section. So that had to do with who could participate in the hearing and what rules of evidence would be used. And subsection C, if at the completion of the hearing in consideration of the record, the court finds by clear and convincing evidence at the time of the hearing, the person is a person that is in need of continued custody, care, and habilitation, Commitment shall continue in a designated program in the least restrictive environment, consistent with the person's need for custody care and rehabilitation for an indefinite or limited period. If the court finds at the time of the hearing that the person is no longer a person who's in need of continued custody care and rehabilitation, they're discharged. And I've added they're discharged in accordance with the next section. So I've broken that out as a separate section. And determining whether a person is a person in need of continued care, custody care and rehabilitation, the court is to consider the degree to which the person has previously engaged in or complied with the treatment and programming provided by the commissioner. And in subdivision 2, in a petition in which placement in forensic facility, so again, we're moving from commitment to placement, a court shall first determine whether an order for continued custody care and rehabilitation is appropriate. If the court does grant that petition for continued custody care and rehabilitation, it then turns to the question of determining whether placement at the forensic facility is appropriate and least restrictive setting adequate to meet the person's needs. If so, the court shall order the person placed in the forensic facility for a term not to exceed the duration of the order of the continued treatment. Yes.
So, right, through all of that, and the question that you probably don't have to ponder over at this point, but is there a role then for the commissioner, and if the individual is requesting, is there a role for the commissioner and or the panel? So just a general question there.
If after the 90 days, the person is initiating the review, what is the commissioner's role? I imagine it would be the same as the commissioner's role if they were initiating the review after a year. I would assume that the 90 days just moves up the timeline.
So something to think about is whether or not that is explicit in the
Sure.
paragraph.
Who's gonna keep track of all this timing and, who needs to be, weigh in, like I've got, what's the makeup of a
Panel?
human
But
community safety panel?
Right, that's the panel we
Yeah.
spoke about at length the last time I was in. So that's in the first and second sections of the bill. That's a panel made up of commissioners, Commissioner of Mental Health, Commissioner of Dale, Commissioner of DOC, Secretary of AHS. And they are making a recommendation as to whether the forensic facility is the appropriate placement. They cannot order as drafted, they could not order a person to be in a forensic facility. The court would still have to weigh in on that decision. But they're the panel that sort of is looking at the data and making a recommendation as to how to proceed.
Does that exist now?
It does not.
So Senator Beach has a question, and then I'm gonna suggest, well, I'll refrain from questions too much, but I thought that one is an important consideration right there.
Okay.
Is it anticipated, this question for you, Madam Chair, process question, is it anticipated that following this committee, that this bill goes to judiciary?
They will look at it, yes. Yeah. There are certain things that are ours and certain things that are theirs, and they'll
Absolutely.
scroll through it, yeah.
Okay. So this is the last of the new sections that I created to sort of break up that one huge section we looked at last time, and this is discharge. So in subsection A, we're sort of just making a statement that there are two ways that a person would be discharged. It would either be through the family division of the Superior Court or an administrative order of the commissioner. Note in that lead-in language that we're talking about three types of discharge. Or somebody might be being discharged from their initial order. Somebody might be on a continued order, and we might be looking at a discharge from a continued order. Or we might be talking about placement at a forensic facility. And you'll see the language as we move through this section. But it would be possible for after a discharge review that a person might be discharged from the forensic facility but still be under a commitment order to the commissioner. They would just receive a placement
It's a
elsewhere.
different placement.
Right. So that all three of those types of discharges are contemplated in this section. In subsection B, so subsection B deals with a court discharge. A person under commitment, a commitment order or continued commitment order, shall be entitled to a judicial review of the person's need for continued custody, care, and rehabilitation pursuant to the previous section, that process we've already talked about. If the court finds that a person is not a person in need of custody, care, and rehabilitation or continued custody, care, and rehabilitation, the person shall be discharged from the custody of the commissioner. Commitment ends. A judicial order of discharge may be conditional or absolute and may have immediate or delayed effect. Now we're turning to what happens if the person's in a forensic facility. In reviewing the placement of a person receiving treatment and programming at a forensic facility, the court may determine that while the placement at a forensic facility is no longer appropriate, or that the setting is no longer the least restrictive setting adequate to meet the person's need, that the person still needs to be in custody. In this instance, the court shall discharge the person from placement at the forensic facility while maintaining the person's order of commitment or continued commitment. In subdivision B, when a person subject to judicial review pursuant to this section is receiving treatment or programming at a forensic facility. Now, this is the language that I pulled in from the House Judiciary draft. Either the state's attorney of the county where the person's prosecution originated, or the office of the attorney general, if that office prosecuted the case, or the victim, or both, may intervene to provide a position as to whether the person's discharge from placement at the forensic facility is appropriate. So
This gets to the question I was asking earlier, actually, yeah.
So this is only, this is not an opinion about commitment. This is an opinion about, or allowing intervention on the question of placement at a forensic facility, not commitment.
Can I ask a question? So the word intervene, that sounds aggressive. I'm wondering if, because this is just making a saying, I don't think they should be committed or they should be committed, like, or just, or
place at a forensic facility.
Sorry.
But intervene sounds more like.
Circle it, Senator.
I did circle it, but I'm
Yeah,
just,
go.
I like I'm wondering if that's too strong of a word. Or if that's
more
not
of a-
another a term of art.
More of
kind
a
thing.
term of art. And I'm happy to, I had Eric, who is my judiciary counterpart, eyeball this last night. That didn't jump out to him. I'm thinking it's more of a term of art.
Okay.
But I will specifically ask him that question. And my instinct is that he will probably say, yes, it's a term of art. We should continue to
Yeah,
use
the
it.
sequential
Okay.
intercept method would probably indicate that it is a term of art.
Okay. So subsection C, we had been talking about discharge through the courts. Now we're talking about an administrative discharge. So the commissioner initiating a discharge. So if the commissioner determines that the person is no longer a person in need of custody, care, and rehabilitation or continued custody, care, and rehabilitation, the commissioner is to issue an administrative order for discharge of commitment. Excuse me. An administrative order for discharge from commitment may be conditional or absolute and may have an immediate or delayed effect. At least 10 days prior to the effective date of any administrative order for discharge by the commissioner from commitment, the commissioner is to give notice of the pending discharge to the committing court and either the state's attorney of the county where the prosecution originated or the attorney general's office if that office prosecuted the case. Now we're moving to the forensic facility. In reviewing the placement of a person receiving treatment and programming at a forensic facility, the commissioner may determine that the placement at the forensic facility is no longer appropriate, or the setting is no longer the least restrictive setting adequate to meet the person's needs, but the person is still a person in need of custody, continued care. Oh, I have to switch those. Custody, care, and rehabilitation.
We're gonna get used to that.
In this instance, the commissioner shall discharge the person from placement at the facility while maintaining the commitment or continued commitment. So same language as we saw for the court discharge. And then we have some language that again is being pulled from that House Judiciary draft. When a person is subject to administrative discharge pursuant to the subsection C as receiving treatment and programming at a forensic facility, the state's attorney or the AG shall provide notice of the pending administrative discharge from placement at the facility and from commitment, so both, if applicable, to any victim of the offense for which the person has been charged who has not opted out of receiving notice.
Can we pause for 1 second? Sorry.
Mhm.
And this is the victim notification.
Mhm.
Thank you.
Can you just remind, I'm sorry, this is just a lot. I feel slightly overwhelmed, but this is for,
Discharge.
all of this language is specifically for intellectual disabilities
Yes.
still. Okay.
Yes.
Yeah.
Okay.
The
And
Venn
then,
diagram overlap.
which maybe I've only managed to confuse people with my Venn diagram, but.
No,
it's
Venn
good.
diagrams are
It's
really
good.
cool.
I
I
wanna
just
see it.
need to see it.
Okay, in subdivision 2B, if entitled to appear and call witnesses in the underlying criminal case, the state's attorney or the office of the attorney general or the victim, or both, may request a hearing on the person's pending administrative discharge from the person's placement at a forensic facility. So again, not weighing in on the commitment question, but on the placement at forensic facility question, which shall be heard 10 days after the request. Once the hearing is requested, the pending administrative discharge shall be stayed until review by the court.
So, I mean, some of the timing of this within the court system is something that's real, in the Judiciary Committee. They're gonna be weighing in on a lot of this.
In subsection D, whenever a person is subject to judicial or administrative discharge from the person's placement at a forensic facility, the criminal division of the Superior Court shall retain jurisdiction over the person's underlying charge and any orders holding the person without bail or concerning bail, and conditions of release shall remain in place. Those orders shall be placed on hold while the person is receiving treatment or programming at a forensic facility, and when a person is discharged from a forensic facility to a correctional facility, the custody of the commissioner shall cease when the person enters the correctional facility.
Can you pause there for a second
Mhm.
to reread
Yeah.
that?
Commissioner Dale.
Commissioner of Dale.
Commissioner Dale. We'll try and go through, to the end. And then we'll come back to this.
Okay, and I renumbered 8846 to fit in those other provisions. That's why it's highlighted, just because we're renumbering it and saying person subject to commitment or continued commitment versus judicial review is currently the title of 8845. There's rulemaking language, which I renumbered, effective date language. You heard testimony that to make the forensic facility, to get it up and running would take longer than July 1, 2024. I was asked to put in a new date, so I have at random chosen January 1, 2025. That is a policy decision for the committee, what date would be appropriate there.
Thank you. This is a lot. This is good, I think, and having the House Judiciary language is extremely helpful, because they did a lot of work after the bill moved along. And then trying to put a framework around folks with intellectual disabilities in the custody of Dale, but also going through the judicial processes. This is a really big step. So what I'm going to suggest to the committee, and I'll take your question, Senator, is I would ask that you read through this again, take some time to look at it, understand it a little bit, the whole thing. Then I'm going to work with Katie, and we'll have Katie reach out perhaps to DMH on the sections related to competency restoration and get some kind of language in there. I am not convinced that there's a whole lot we can do in the time that we have. That's a huge another area, but just to allow for some forward movement on that, so we can talk about how to do that. So that's where we are. Senator Hart, you have a question?
Yeah, so I kind of wanted to know, because so much of this is related to the whole question of competency and competency restoration that I wondered, so that was one thing I was gonna ask, but also, could you tell us, have you done agenda planning for next week? Can you tell us when this is on
I'll let
again?
you know tomorrow.
So that, because I need to read through this and think about this more, and I need
You
to know
have-
when, because I have so many other things to
Sure.
do,
So
so.
we can't post, as you know, we can't post the agenda until Friday afternoon.
Yeah,
And it's in progress. We're working on the agenda, and I'll try and let you know as soon as I go back through and see
that
where
would
we
be
are.
helpful too.
Yeah. Go ahead.
I look forward to going back and reading this, but at first glance, these changes are helping me get
Yeah,
behind.
no, I
the-
think
the
Katie's
bill.
organization
Yeah,
of the
it's really
information has been a huge
Thank you.
improvement. A vast improvement. It's great. Thank you. It's been good work. Thanks a lot. So we'll be in touch about the competency restoration piece, which is, with intellectual disabilities, it may have does have significant meaning, because as we understand, it may be difficult to restore competency for folks with intellectual disabilities. That's the area that's confounding. So, other questions?
Well, I guess also, are we gonna get, because there's the legal question and then there's the facility question. And I feel like they're obviously connected, but my discomfort is still around mixing these populations in the same forensic facility.
We'll try and sort that out. We'll, in conversation, maybe we can have both Dale and DMH weigh in on that question. I know that both of them are listening to this. That's a question that the committee would like to have elaborated, an answer that will help us understand whether or not that's the right direction. So I would ask Dale and DMH, bring us back that information, and we'll have you in when we're looking at the bill next. Be good. Okay. Good. All right. Thank you, Katie. It's terrific. We are behind a little, but we do have time for, to move along, and I'm gonna suggest if you'd like to take a break to do it on your own. And so we can move on to 197, and we do have folks in to testify on the bill, the sections, the PFAS bill. I'm thinking that we can probably accomplish all the testimony in the time that we have. Yeah. So let's go to 197.
I'm sorry, I was thinking, I thought it had C's coming on, but it went away. Thank you. Morning. Morning, we usually see you in the ed committee.
I know.
It's a change.
Let's make it the rounds.
I am.
Elkhart this morning.
Elkhart this morning, House Ed this morning. Here now,
So, okay.
Hey, Matt Chapman. I know.
up there.
Just to let you know, if we can go off, no, don't go off live, but to let you know, that Sarah Owens, our state toxicologist, has a time frame, but I think we're gonna be fine with that. So-
I can go really quick, and then we can I can either step off of the stand. And
No,
you can
you're
come
fine
back.
right where you are. So
All right.
let's remind ourselves of S 197. We do have the bill in front of us. It's, we looked at the agricultural pesticides section with the Ag Committee last week, and this time we're looking at those sections that relate to us, including the Department of Health sections. So I'm going to, we'll just listen to testimony. So Matt, thank you for being here, and please introduce yourself for the record.
Yes, sir. So my name is Matt Chapman. I'm the director of the Waste Management and Prevention Division within the Department of Environmental Conservation. And I'm here primarily to speak to sections 1 and 2 of the bill. So DEC kind of has a coordinating role on product related issues. Just to give the committee a little bit of context around PFASs, and I'm going to assume the committee, because of its work, has a general understanding, but just so you're aware, we believe there are about 14,000 chemicals in commerce that are classified as PFASs. Of those, we can test for approximately 40 of them and have environmental standards for about 6. This may come as a surprise to the members of the committee, because it was a surprise when I found out. There is not really a universally recognized definition for what is a PFAS. Right now, EPA, its various programs and offices, are using 5 different definitions, all of which have different effects on what it is that we're dealing with. The one the state of Vermont has adopted, which is used both in Titles 10 and 18, we've defined PFAS as being one fully fluorinated carbon atom. That's generally consistent with what the European Union's done. I think the major difference between our approach and the EU's approach is that the EU has basically exempted broad product sectors of critical sort of industrial activities or commercial activities where there's no known alternative or substitute for PFAS in those classes of chemistries. So our definition's overbroad. It covers things that are technically have one fluorine and one carbon atom, but they don't have the properties that we normally associate with PFASs. So they aren't persistent. They aren't. They don't have the mobility, the sort of issues that we normally see. So both the agencies of Agriculture and Natural Resources and Department of Health have begun the conversation around, especially as we broaden the scope of products that we're talking about, this definition becomes more and more relevant. And so we're talking about what is an appropriate alternative, and I think we're going to bring that to the House when it takes up its work on S25. It starts to become important when we're talking about House boundaries. So again, just to sort of bring us back to S197, and just to give the committee an appreciation of the industrial sectors that PFASs are found in. They're found in things like textiles and cookware, which I think you're aware of, but they're also in paper products and ink, electronics, including computers and electronic servers, cars, cleaning products, including shampoos, floor polishes, waxes, concrete and metal cleaners, and they're in a lot of renewable energy technologies. Mm-hmm. So heat pumps, EVs, solar panels. And while a lot of these products, there are substitutions, and those substitutions are less harmful, there are a number of these sectors where they're critical product lines and there are not available substitutions for PFAS within those product lines at this time. And it's basically from sort of that foundation why we have concerns with sections 1 and 2, because the inability of the state to regulate and buy things like heat pumps, electric vehicles, paper, computers would be problematic. And I think that, so generally speaking, we're not supportive of the approach that's presented in S197. I guess I would say we agree with the general principle that we need to be moving towards taking PFASs out of commerce, and we, ANR, is playing a leadership role in working with other state agencies of natural resources to try and come up with model legislation that New England states and Mid-Atlantic states could work collaboratively on to basically phase PFAS out or restrict PFAS in core product sectors that we think there are easy sort of wins where there are substitutions available, and then having processes in place to phase it out of all consumer products, but where agencies can step in and say, no, this is a critical product, there aren't available substitutions, or alternatively, the substitution is worse than PFAS when we're dealing with it, which happens unfortunately as well. So that that model legislation is currently being considered by a group called the Northeast Waste Management Officials Organization, or NMOA.
And you're the lead, and you are. a leader in
I
that.
am.
We
I'm
appreciate
the
that.
chair of the model legislation drafting committee.
Cool. See, we have somebody significant in front of us.
So, and we're progressing towards trying to, you know, my peers in other jurisdictions, we're meeting in February and March to try and finalize that.
So, let me just share with you that your concerns are our concerns, or my concerns, and
Sure.
how to implement this and administer it is a huge question. So what would be helpful? Two things. One, have your testimony in writing, but
Sure.
as part of that, perhaps a suggestion that would allow for the bill to go forward, and the concept of restricting purchase of PFAS to go forward, but at the same time to recognize what you're doing with other states regionally. I mean, if there's something that you could help us with, that would be.
I mean, I'm certainly happy to take a look at what other jurisdictions are doing and
Yeah.
seeing whether there's anything where I might be able to give some suggestions to the committee on ways to move forward. You know, we're certainly looking in the model legislation around a standard provision that has a purchasing preferences provision, which would be different, right? You would have, you know, BGS in Vermont have preferences towards products that don't contain PFAS when they're doing their purchasing exercises. I haven't consulted with BGS around that and gotten their opinion on it.
It's another story.
Fair enough. So.
Yeah.
Were you done? Can I ask a question? Or do you have more to say?
No, well, I mean, I'm happy to say
There's
a
a
few
lot
more
to
things,
say.
but I'm also happy to
Okay.
take questions.
Okay, so I just, it is cool that you're doing this model legislation, because as we've taken up these bills over the years, you've heard me say before, why can't we look at the big picture? I feel like we're just like knocking off little things, whereas I'd really like to take a more holistic view of, we shouldn't be using PFAS at all unless it's absolutely the only option, that, and as you said, the other options are a worse option, you know what I mean?
Yes.
So two questions. One, you mentioned the EU and how they're handling it. In your work on the model legislation, are you trying to do kind of what they're doing? Because my understanding is they look at whole classes of chemicals, restrict them or prohibit them, and then make exceptions only in really necessary cases.
So I think it's fair to say that New England has some experience in the mercury realm on banning mercury in consumer products. We kind of have a structure in place for how we did that in New England. And we certainly have borrowed from that. It's not, I mean, the EU has a very robust and well-developed program around toxics management that is very different than the program we run in the United States. I think that there are benefits to the EU program. It would be difficult to make a transition in the absence of federal leadership towards something in that direction.
EU reach is like a huge reach.
Okay, that's fair enough, but I also wonder if in the model legislation, you are trying to take a more holistic, not like, you know, knocking off, you know, ski wax and then carpets and then blah, 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 but just really more broadly.
So the draft that is out there right now, and it's not final yet, has, I believe it's 12 priority product lines that would come into effect in relatively short order. And then it would phase out PFAS in all consumer products. So things are basically a retail sale with you could file for an exception from that retail sale ban.
Who's you?
You, the manufacturer of a PFAS containing
And who
product.
decides the exception?
The agencies. Well, an agency who's implementing the law, and it also provides for a regional clearinghouse approach where we could basically have state agencies could join together and have a regional clearinghouse where we could come together, collaborate, decide on those decisions, sort of universally, and then implement them as state agencies.
Okay. Because we've had testimony from those chemical companies, and they are well-funded and extremely persistent.
Right.
Just like the chemicals.
Just like the process.
Just like the chemicals.
Oh.
So, Matt, thank you for your testimony,
Sure.
and if we can get something in writing, and then as we go forward, we do want the bill to go forward, and
Okay.
right now, you've indicated that the definition is too comprehensive
Yes.
in this, well, we would be covering everything, which is, well, in many ways, a good thing, but in other ways, difficult to manage and administer, so any help that you can give us as we go along in, improving language, would be useful, but we'll do that.
I will.
Good. Okay, we'll be talking, I know.
All right.
Yes.
Sounds great, Senator. Thank you.
Thank you, thank you. So, I am gonna move to Sarah Owen because she is on does have a time, limitation. And I'm gonna ask each of the folks who are testifying to keep yourself to 7 minutes, if you can. Let's see how that goes. Go ahead. Sarah, welcome, and thank you for being with us. I don't think you've testified in our committee before. We know who you are, and we thank you for the work that you're doing. So it's great to see you here, even if it's not in person.
Yes, thank
So go
you.
ahead.
Sarah Owen, I'm the state toxicologist for the health department. And I would just first like to say that we look forward to working on the definition of PFAS with DEC and our other colleagues in the state. So thank you, Matt, for describing that so well. I want to take just 1 minute and talk about Section 5 of the bill. So Section 5 would require the health department to put a statement on our website that private and public drinking water sources contain PFAS. And I just want to point out that there's been quite a bit of testing, both of private wells and public water systems in our state. Roughly 65% of the private water systems, private water supplies that were tested did not have PFAS. And around 80% of the public water systems that were required to test did not have PFAS. So I would just ask that that language be reconsidered or not required. Moving on, I think you were interested to hear our response to Section 4 of the bill, which would require a registry for adverse health outcomes that are attributable to PFAS. So we know that exposure to PFAS is unfortunately associated with a really wide range of health outcomes. These include developmental effects, which of course target a developing baby, increased risk of cancer, changes in liver enzymes and liver cells, changes to our immune system, which can include decreased antibody response to vaccination, changes in our thyroid levels, and increases in cholesterol. So some of these health outcomes are not routinely measured. So for example, when we all go to our healthcare providers to get a booster for any of the things that we get vaccinated against, our healthcare providers are not taking our titers to see how we're responding. These health effects that are associated with PFAS are also really common. They're really widespread, and they already have a really high rate in the population. So for example, outcomes like increased cholesterol or changes in thyroid hormone levels, those could be attributed to many causes other than PFAS. So requiring reporting on such a wide scope of these health outcomes would be an incredibly complex burden on healthcare providers, and it would be really difficult to interpret that data. So for these reasons, we don't support the creation of a registry for PFAS health outcomes. Under 7 minutes.
Oh, wow. You get a gold star for that one. Thank you. Can we have your testimony in writing?
Yes.
Please? That would be terrific. And then we'll be going through the bill and talking about the elements that you've identified. Obviously, Matt Chapman has already identified the definition, And then the registry for something as, like PFAS that causes so many diverse outcomes, something we'll have to talk about. There are some, so we'll look at that. And if you have recommendations for how to improve either of the sections that you've identified, that would be very helpful. So, for example, I can think about, rather than say your drinking water is contaminated, to have some educational piece either on your web page or for folks who have already identified PFAS as in the water, groundwater, surface water. Okay. All right, thank you. It's good. All right. So other questions for Sarah?
Got a question.
Go ahead.
I saw your letter that went out to some of the property owners with wells. How's the response been from the general public to test their water? Have you had good results?
I think you might be talking about the effort that's led by DEC to test about 500 private wells for PFAS. Is that what you're?
Right.
Yeah.
Yes.
We have gotten some calls from homeowners. That information, the results are provided by DEC or by the lab to those private water system owners. And when people have questions, they call us, and I think people have been appropriately concerned about PFAS in their private water. We help them understand what options they have for treatment and help them understand the potential health effects of PFAS.
Was that just a random sampling of homeowners with wells? Because I didn't get one. I know some of my constituents did.
Mm-hmm.
Yeah.
I would let DEC describe that testing effort, as that was they're the lead on that testing.
Okay, thank you.
Okay, so that's a question out. Maybe you can get us a response. Okay, any other questions for Dr. Owen? Okay, thank you for being with us, and
Thank you so much.
Yes, we may reach out again.
Of course.
Don't disappear. Okay, good. All right, so Kyla Bennett. Is Kyla Bennett here? Kyla Bennett?
I am here.
Oh, you're on. Oh,
Yes.
Okay, good. Thank you.
Yes, sorry, I couldn't get my microphone on.
We don't see you, so that's good. Thanks. Thank you for being here. So introduce yourself for the record, and then we'll listen to your testimony.
Sure. My name is Kyla Bennett, and I am the Science Policy Advisor for Public Employees for Environmental Responsibility, or PEER, a national nonprofit based outside of Washington, D.C. I'm physically located in Massachusetts. I have a PhD in ecology and a law degree. Thank you so much for allowing me to testify this morning. By way of background, I was the one who discovered PFAS in Anvil 1010, which led to the discovery of fluorinated containers leaching PFAS into their contents. I am also the co-author on a paper that has been submitted to a peer-reviewed journal. It should be publishing soon, and it's on PFAS in pesticides. So I am testifying today to urge you to keep sections 6 and 7 in Bill 197, which is a critically important bill. I want to share information with you regarding why PFAS is in pesticides in the first place and why it is such a huge problem for human health, farmers, and the environment. Dr. Owen just described for you the vast array of health effects associated with PFAS, and I agree with her. Cancer, developmental problems, pregnancy problems, endocrine disruption, immune suppression. I could go on and on. What you need to know is that some PFAS are toxic in incredibly tiny amounts. Indeed, in March of 2023, EPA stated there is no dose below which either PFOA or PFOS is considered safe. Accordingly, EPA set its proposed maximum contaminant level goals at 0 for these compounds. So those Proposed MCLs should be made final any day now. We are finding PFOA and PFOS in pesticides regularly. So keep in mind that there is no safe dose of these two very dangerous PFAS. PFAS get into pesticides in one of four ways. The biggest contributor to PFAS in pesticide products is the fact that they are in active ingredients and they're degradants. Of the 471 synthetic active pesticide ingredients that are currently registered here in the United States, 66 or 14% are PFAS. So 14% of our active ingredients are PFAS. Unfortunately, this practice of using PFAS as active ingredients has only increased over the past 10 years. Of those registered ingredients that have been approved over the past 10 years, 30% were PFAS. So it is speeding up, not slowing down. The second reason we're finding PFAS in pesticides is through the inert ingredients. These are the emulsifiers, the solvents, the propellants, things like that. Inerts are not required to be publicly disclosed on the pesticide label. PFAS can aid in surfactancy. So in other words, if you spray something with PFAS in it, it spreads more evenly. It also assists the penetration of PFAS into living organisms. It also increases the shelf life and stability of pesticides. So until recently, EPA had 20 PFAS listed as approved inert ingredients for pesticides. After we hounded them for quite some time, they removed 12. There are still 8 on there as approved inert ingredients, and we never know if they're in there because they're not on the label. The third way PFAS can get into pesticides is through adjuvants. These are the products that are added aftermarket by applicators to reduce drift or enhance pesticidal effects. These can be fluorinated. Unfortunately, the federal government doesn't regulate these. I think the only state that does is California. And the ingredients are considered proprietary, so we have no way to know if they're fluorinated or not. And the last way that PFAS get into pesticides is through contamination. The post-mold fluorination process of HDPE containers creates massive quantities of PFAS, including 3 that are listed in your bill: PFOA, PFNA, and PFDA. EPA found total concentrations in the 10 to 60 part per billion range. Remember, they said PFOA, there's no safe dose, and we're regulating it in the part per trillion range. This is in the part per billion range, and this all leaches into the pesticides. So it's estimated that 20 to 30% of all hard plastic containers used in the agricultural sector are fluorinated. That means 20 to 30% are contaminated with these high levels of PFAS. It's unintentional, very little is known, but it's there. And I would like to clarify some statements that were made in the joint hearing last week. In December of 2023, EPA did issue 2 orders under TSCA against Enhance, the company, the only company that engages in this post-mold fluorination and creates all that PFAS. They ordered them to cease all fluorination for all of their containers, not just in pesticides, by February 28th of this year. However, Enhance appealed to the Fifth Circuit. Oral arguments are Monday. The Fifth Circuit is not known to be an environmentally friendly circuit, so we have no idea what's going to happen. So it's very possible that those orders will be held null and void. We won't know for another few weeks. There is no better way to contaminate our soils, our waters, and our food supply than applying pesticides with PFAS. In 2021, 1 billion pounds of pesticide active ingredients were applied on farmland throughout the country. This makes pesticides some of the most widely distributed environmental pollutants across the US. And PFAS are so persistent that each subsequent application adds more PFAS into our environment. And if I could just touch on your definition issue, I think you should hold that definition. That definition of 1 fully fluorinated carbon is what all the states are using. It's what the Department of Defense is using, and it's what the rest of the world is using. And the reason we want it broad is because what happens is when we start regulating these things on an individual basis, we call it the whack-a-mole approach. What happens is the companies just tweak the formula and put out a new PFAS that's not regulated, but it has the same adverse impacts. We only have toxicity information on about 129 PFAS out of 14,000. We really need to use the precautionary principle here because all of them are persistent, even the ones with just that one fully fluorinated carbon. It's that carbon-fluorine bond which makes them so persistent. Most of them bioaccumulate, and every single one we have tested is toxic. So don't take the chance. Please leave that definition in there. We must protect farmland and farmers from these chemicals. We have cases all over the country, Maine, Michigan, Texas, where farmers are being forced to stop selling their meat, their dairy, and even their vegetables due to PFAS contamination. Farmers are losing their farms and their livelihoods. While many of these cases are from PFAS and biosolids, as PFAS become more tightly regulated by the federal government and the states, the potential exists for PFAS from pesticides to contaminate farms and farm products, not to mention drinking water, to the point where they can no longer be consumed. We are starting to see lawsuits from PFAS-contaminated products, and people will start suing farmers. One note about testing. It should be noted that the results of PFAS testing by different groups have produced conflicting results that appear to depend on the analytic methodology used and where the testing was conducted. This simply confirms the difficulty of testing complex mixtures like pesticides. However, while I am not at liberty to say more at this time, please note that PEER is challenging that EPA memo which disputes the findings of large quantities of PFAS in some pesticides. We are asking for a retraction. Multiple scientists have found PFAS in pesticides. They are present. It's a huge problem, and EPA knows they are there. So in conclusion, the very long-term impacts of using mixtures of extremely persistent chemicals on farmland in Vermont every year is cause for concern. Most, if not all, PFAS and pesticide products are going to be legacy pollutants, and their ultimate impact on human and environmental health are largely unknown. As Rachel Carson famously said, if we are living so intimately with chemicals, eating and drinking them, taking them into the very marrow of our bones, we had better know something about their power. We do know the power and the danger of PFAS. I urge you to keep Section 6 and 7 in Senate Bill 197 to protect Vermont farmers and its citizens from these devastating health and economic impacts. Thank you.
Thank you so much. It's a very compelling testimony. And two things. One, if you could please send your testimony to Kiki, and then we'll have it posted on our webpage, because I think it is important. Have you testified in Senate Agriculture at all?
I'm going to tomorrow morning.
Okay, that's good. All right, that's helpful. It's good that we have some consistency and understanding in the bill. Then the other question I was going to ask you is if you wouldn't mind identifying and sending along your article when it's ready.
Sure, absolutely. It probably won't be out for another month or two, but I'd be happy to.
That's okay. I enjoy reading, and I think other folks do, so
sure.
That'd be great. And your comment on the definition, I think we did hear from Matt Chapman that he wasn't going to suggest we change the definition as it leaves the Senate, but it will be important, I think, to have that if we don't have the full dialogue and hear that our cohorts in the House have that discussion. We'll see how that goes. And thank you for your work on this. It is greatly appreciated.
Thank you.
Thank you. I have one quick question before you go. I'm getting interested in the difference between organic and biodynamic farming, and I'm wondering if you've seen PFAS on organic products as well as non-organic.
Yes. In fact, there was just a recent article that came out that showed really high quantities of PFAS in organic kale. The reason that we assume that organic farms would be less likely to have PFAS contaminated produce or milk or meat is because organic farms don't use synthetic pesticides that contain PFAS, and they also don't use biosolids, which are a huge, huge reason that we're getting PFAS in food and other farm products. However, the suspicion in that one case is that the water being used was highly contaminated. The other thing that we've just recently found out, because we're involved in this lawsuit against Enhance, the fluorinator of the plastic containers, HDPE is the number 2 for the recycling. You know how you have the recycling number on the bottom of all your plastic stuff? Number 2 is, it's a pretty popular, it's one of the ones that's recycled frequently. And unfortunately, these fluorinated containers and their PFAS have contaminated the entire recycling stream. And one of the products of that plastic recycling is irrigation pipes. So we don't know, in that one case of the highly contaminated kale from an organic farm, if they had those recycled irrigation pipes or if their water was contaminated or both. But generally speaking, all other things being created equal, organic produce should have far less PFAS than the conventionally grown. That particular case was probably a water contamination or an irrigation contamination pipe issue.
Where was that? Can you tell us where that occurred?
I'm sorry, I don't remember. I just saw the article recently and I can't remember what state it was from. I don't think it was New England.
Thanks.
Okay, other questions? Thank you very much. We may come back to you at some point, but we greatly appreciate your knowledge and sharing that knowledge. Terrific.
Thank you so much for letting me testify.
All right, so we're going to move on to Jesse Hammond.
Hello.
Good morning.
Morning.
Thank you for being with us.
Sure. I'm Jesse Hammond, Division Director for the Division of Health Statistics and Informatics at the Department of Health.
All right, so we're talking about S-197, and if you could give us your thoughts within a 7-minute period, that would be awesome. I know you've got more than that, but.
Yes, I will do it in much shorter than that. I'm also speaking up on Section 4, following up with Sarah Owen's testimony, and I'm specifically speaking to some of the complexities with implementing a registry at the Department of Health for this. This registry would be significantly more complex than some of the other very recent registries we've been asked to implement, such as the ALS registry we recently implemented. This is because that PFAS registry would need to be complex. It would be complex, it would have to be robust, and it would require a technology solution. And while the cost can't be determined until the specific system requirements are developed, this type of project would cost at least $300,000 to $500,000 to develop and implement. And this excludes the cost of any ongoing maintenance or enhancements moving forward. Given the already existing data modernization projects and needs at the Department of Health, PFAS registry would likely take 3 to 5 years to implement. And developing this registry would be a substantial lift over multiple years, and VDH does not have the existing funds or staff to support that effort.
Oh, as a member of the Appropriations Committee, that's a scary piece of testimony. Thank you. Can you send us your testimony so we can post it on our webpage?
Yes, of course.
That would be helpful. We've got a lot of thinking to do on that little Section 4. Yeah. Okay. Questions? All right. We're good. Thank you so much. I know there are others who want to testify on the bill, and we will put it up for a testimony. I forget right now whether it's up next week or not, but we'll get there. This is a bill that we need to keep up on the table, isn't it? I'm thinking.
Kind of like S-25.
It feels like S-25, doesn't it? Yeah, it does. We still have others to hear from. I think Section 4 has a lot of implications for record keeping and data, and that may not be productive in a way. So we'll be talking with Department of Health and others about what we might do with improvements there. It's not that we want to drop that, but we do want to have some, it's a health issue, there's no question about it. We don't want to scare everybody to death, but maybe we do, I don't know. So we'll keep working on this one. Oh, okay, so I'm gonna suggest, I know you just came from your break, I'm gonna suggest like a 7-minute break, please, and